CR number 1217/1997 is actually a criminal number, right? A criminal review number, that kind of a thing. So it's a case thing that we refer to. And once again, INSC is a journal name. COGCC is actually the international manner of referring to a journal and everything. So there's that. Oh, and I'll also tell you, this is a very interesting thing that I think you should really keep handy, is how to find the cases on a court website. I think that is extremely crucial for you to know. So I'll tell you how to find a case on Supreme Court. So sometimes what happens is on Manupatra, Indian Kanun does not give you like a true case, like how a case has been decided and everything. Sometimes Manupatra runs into an error and something. So it's not exactly reliable at all times. For example, I'll show you a very common example that, and also never rely on Manupatra beyond a certain limit. Okay, please just don't. Never helps you regarding anything. Okay, so if you can see, there are these two judgments. Okay, there is a deputy CIT, there is a CIT, and then we have a CIT versus also. We have a CIT versus and all that, right? So you see, this is a 2007 judgment. This is a 2020 judgment, and this judgment is not even opening up over here. If we open it up, this will be the 2007 only. Okay, and then we have the CIT versus this, which is a 2011 judgment, right? Now, which one is the one that we go with? If we know only the case name, but we don't know what else is in that case, which one do we go with? Then what do we do is usually is that we just cross-check if this is actually the case that was decided upon. So you see this date, because Indian government does not always give you the citations. So you go by this date, okay? So when you go on Supreme Court India, it will tell you different avenues through which you can know. Case number, diary number, judgment date, judge name, parties, act-wise, constitution bench, and free text. Free text never works. I've tried it a number of times on different aspects, never works. Constitution bench never works. Okay. Act-wise never works. Parties never ever works. I'll show you this right now. Hindustan Coca-Cola Beverages. That was a 2007 judgment. 2007 January. We go with 2007 1 January to, let's say, November 30th. Sorry. See, doesn't show. So it never works. You will think that there was never a case between these two dates regarding Hindustan Coca-Cola, but there is a case. We have seen that. There is a judgment. Then there's a judge name, too many judges' name, never works. And also, this really doesn't give you like a true picture of all the judges. This only provides you with the 31 judges who are sitting on the bench and a couple of judges which are very well known, like for example, Justice Rishikesh Roy and all those. And judgment dates is the one that I usually go with, and diary number or case number. These are the only three things that works. And the judgment date also sometimes never works. So just be careful about that. Okay, so we had the August judgment, right? So we'll go with August. That was a 16 August. So we'll put the date around as 15. We'll do it as 2007, August 17, 9100, and then we go submit. So you can see this, right? Hindustan Coca-Cola Beverages, Commissioner of Income Tax, case number, diary number. Now the thing is that referring to a diary number is extremely helpful. Note down the diary number, which is 2203, okay? Why? Because when you write the diary number 2203, 2007, not this. This is a appeal, civil. Okay, so see, this will tell you a lot. Is it a tax case appeal? Is it a civil appeal? Is it a special leave petition appeal? Is it a criminal appeal? Is it a writ petition? It will tell you a lot, right? So, for example, you'll have to choose among these. Which appeal was it, and how do you navigate? It was a civil appeal. Case number was 3765. 3765, 2007, 4248. It's all referring to the same judgment. Damn it. Okay. So what usually happens is that if you see like an ongoing case, like for example, what ongoing case should I choose? Is there? Oh, wait, I think I can. There's an unsold judgment. Okay, I am going to take like a little bit of time because now I have time, and I think that you also have time, and I think I can show you like the finer intricacies of how finding a case really works. Okay. So we have this. We have ITA 160-2015. We have ITA, where is income tax appeals? Do you see income tax appeals? I don't see income tax appeals.
Tax reference case.
Yeah, no, that's a whole different thing. And also, please start appreciating the difference between written petition, writ petition, writ petition civil, writ petition criminal. Then we have a writ to petition criminal. Like start appreciating the differences between these two similar, like small things. All right, that will really help you into differentiating the case. It's not here. Damn it, I wish I could show you like really good case. So what happens is that if you have a diary number of a particular case, then that really helps you into getting like all the details about the case. So where can I find a diary number of a case? Let's see. Oh, wait, what we can do is very interesting thing. I'll show you the cause list also today. Then there is a cause list that is revealed. Yeah, there we go. Right. So, for example, this will be like cause list for all the cases on that particular day. So we have a case number this, okay, which is a SLP criminal law 5978-2017. Let's go on the case status. What was it? That was a case number SLP criminal law. Okay. SLP criminal 597-2017. 5978-2017. 7872. Yeah. Can you see all this? This is all the information about that case. Like all who are impleaders, who are petitioners. Oh my God, these are a lot of petitioners. Who are the advocates? Who are the impleaders, advocates? Then we have interveners. And these are, now we come to the important stuff, okay? So this is like a judgment order that has been given in that case. Okay, these are all the orders that has been given into that case. So for example, we have a 25th February order, which looks like this, okay, which has that the office report that amicus curiae has deposited amount and everything. So we know like what is the progress of the case also. Then we have the defects, if there are any defects or default. Like for example, a non-filing of office report was done, and we have court fees, we have notices that has been issued, like notice of hearing, letter to advocates. We have all that stuff. Yeah, earlier court details matter a lot, right? So we know, the parent court for this was High Court of Delhi, and it's the High Court of Delhi judgment that has been challenged by Ashutosh Kumar. And in these two particular writ petitions, no judgment was challenged. Why this is important is that sometimes it helps us to find where exactly is this case coming from, which judgment exactly has been challenged. Because if you read judgments on Indian Qanun, it will simply say that this was a criminal appeal and this was the ITA number and all that, and this has been challenged and everything, which is not always the case. If you read this case, you will never get to know where this case is coming from, like what exactly is the court that it is coming from. Sorry, this is the Unsel. Yeah, this is the Unsel one. If you read the, yeah, let's see if you can find out what is the ITA. bench. Yeah. See, these are the two appeals by the revenue, and they have been come for assessment and everything. When you see the whole citation, then you know that the ITAT is of course in Delhi because the High Court is in Delhi. But if the case was in Supreme Court, then naturally you would not have come to know about that. So there's all this stuff that you can get to know. You can get to know all the case details that are going and everything. Sometimes the Supreme Court cases website, no, not this, wait. Supreme Court Observer. So Supreme Court Observer is like this very niche website that really helps you to track certain cases, okay? And the only reason why I'm mentioning Supreme Court website is, for example, if you get a case on CAA in a moot problem, then you will really need to know what exactly is going on regarding the CAA stuff and what has been the arguments propounded in front of the court. So we can go with CAA, we can search over here, and it will reveal, see, CAA, plain English summary unions reply. So they always give you like they always give you case documents also, like what exactly was the counter affidavit that was filed, what was the union reply, what was the petitioner's reply. So you can go through all the arguments that are happening in real time in the Supreme Court case, and what exactly is our Attorney General arguing in front of the court. Because courts are usually sometimes really shut off from the outside world, so you never get to know exactly what is happening. And you might get a case regarding that. So that becomes really interesting when you try to find a certain document behind that. So that's why Supreme Court Observer is a very helpful website in that regard. And naturally, the judgment website is also helpful when you try to find a judgment on it. Similar procedure is for the High Court and for the district courts also. You go on, for example, let's say e-court website, make it like your pinned website in your domain, whatever you use. Then you go to the Delhi Court website and you can see that there are judgments that have been given. So you just do a PDF judgment search and then you search it on the basis of case number, judge name, judgment date, party name. All right. So for example, you can search on the basis of judgment date for answer, which is 26th August 2015. And 2015 August 26th. Submit. There you go. So all these cases were decided on 25th, and there we have our answer case. This was the judgment, exactly. Okay. The only reason I'm saying is that sometimes when you go into the proper moot court competitions, and right now you have virtual moot court competitions going on, so you might have to share your screen. It does not look good when you have an Indian Kanun judgment on your screen. Moreover, even if you're, personal, like when you're standing in like physical appearance, then you have to give a compendium. And in the compendium, it just looks good if you have like a proper official sourced judgment or not an Indian Kanun judgment. Just doesn't look good. Okay. And compendium is actually, so whatever cases that you use in your memorial, you have those cases in a compendium, highlighted and extracted and each and everything. So you have that kind of a thing. Yeah. Okay. I hope that's done, right? So, so now, do you have any more questions before I go further? Oh my God. Do you have any more questions? Or should I just go on with a memo?
Go ahead.
Okay, all right. Cool, I'll just go ahead. Okay, so I'll share my screen. Can you see? Wait. Okay, now we have cases cited, okay? And also, you know the difference between appellant, petitioner, respondent, defendant, right?
Yes, ma'am.
Okay,
Yes.
perfect. So we have statement of decision, we have statement of facts. Statement of facts should ideally be just one page, 1 or 2 pages long and never more than that. Because this was an internal memo, so we did not really care when we pasted, copy pasted all the facts because we were running short on time at that time. But if you do form a statement of facts, it should not include this information. This does not matter to our case. Any geographical thing that they are giving does not matter to our case. All that matters is what was the chain of events that took place until we had filed this case. Okay. Then we have a statement of issues, which is mentioned in this. And then we have a summary of pleadings. All right. So summary of pleadings is basically like this very short form of your like what exactly is your case being argued, right? So this case was actually in a fictional land of Ozala, and which was peri materia to India. Peri materia means like almost similar. So because of which we use right to equality and not Article 14. We use right to liberty and not Article 19 and 21 and all that stuff. So, and we did not go into the nitty-gritties of it. And we added Section 3 of Epidemic Diseases Act and everything. So this, so summary actually includes all, like whatever you're going to say, the legal part of it, right? What is your legal analysis regarding that we humbly submit that our particular issue should be ruled in our in our favor, mainly because of this thing. So sometimes you cite a case in your summary, sometimes you cite a section in your summary and all that. All those cases and summary that you cite, all those cases and statutes that you cite in your summary form a crux of your furtherance, like for your arguments advance. Then you cite your issue 1 and then you have like each and everything mentioned like this. Then we come to this particular thing, the footnoting. The footnoting, I know the footnoting styles of Oscola, Blue Book, ILI, and possibly APA, but no one refers to APA. So Blue Book is the American style of footnoting, and it gets revised every year, almost not every year, but like 3-4 years for sure. Oscola is the Oxford Scholar citation style, and then we have our own Indian style, which is ILI, which is Indian Law Institute citation style. So citation style doesn't really matter. You don't really get disqualified on the basis of this, but it really helps you in getting marks. So that's all. Your memo also gets judged on basis of certain marks. So this goes like that, and then you have a final prayer at the end, which is just this, that your issues should be reaffirmed. That's it, nothing more than that. So we have this. That is how you make a memo. All you have to do with regarding the arguments advanced in a memo is just an elaboration of your summary of pleadings, right? So for example, if you have a constitutional matter and you are saying that she should be given bail, then you argue on the basis of Article 21, you argue on the basis of Article 14, you argue on the basis of Article 20, which provides for how strict should the the imposition of charges on an accused be and everything. That is actually my internal memorial, Aditya. So I have actually shared the KK Luthra link that won the best memorial award, and I really want you guys to have like the best memorial ever. So naturally refer to that memorial. For the internals, you don't when you actually take part in moot court competitions and when you actually have to sit for internals, you naturally won't go through that much of a rigorous exercise. So and you also have to present only from one side and not from both the sides. So that really matters a lot at that time. And so any kind of like prelim research will also do for you to clear the internal. So you just have to be very good with your fundamentals of law for that. I believe I've covered. Not all memorials are 26 pages long. Sometimes the moot court competition organizers actually give you the page limits. So for example, they tell you like your memo should be maximum 25 pages long. So you have to make, naturally the memo gets stretched to 25 pages long because you have a cover page, you have a prayer page, you have the index and all that stuff and everything. Your arguments advance is usually only 10 pages long. So that's usually like the frame of reference that you can go ahead with. But the average length, I believe, for a memo is 26 to 28 pages. So that's what I think you should aim for. That's it. And also your oral arguments, regarding your oral arguments, you have something called a transcript. Okay. I don't know if I should show you my transcript for the last memorial or not, because that was really like a very rough kind of a thing that I referred to. So what a transcript is that you know that what summary you have given in your arguments and what exactly are your arguments advanced. So what you do is that you fragment those arguments into different sections, right? So for example, if you're arguing on the basis of a criminal statute, right? So like a murder statute, then you will cover all the cases covering what exactly is a mens rea and is the mens rea fulfilled, is the elements of mens rea fulfilled in this manner or not. Was there an actus reus? And then you also cover whether was it part of a conspiracy, or whether it was unintentional, whether it was in private defense. So you cover all those aspects, and then you also cover whether the charges levied under this particular thing are justified or not. Okay, so under those particular issues, you have certain cases that you have covered, and all those cases are conveying a certain point that you want to elaborate to the judge that, listen, my case is the most favorable case that you should go with, and in my favor is the judgment that should go because of these particular reasons that I've presented in front of you. Okay, the thing that you have to keep in mind while doing your oral arguments is that not read out your memo first. Never read out your memo. That doesn't look good at all. Second, when you have a transcript and when you have like issues covered A, B, C, D, and if a judge asks you a question which is actually about your issue D, and you have not gotten to that, and if you answer that issue D, because you have to answer the judge, right? So if you answer the issue D, make sure that you have enough presence of mind that you do not end up reiterating issue D. Okay, the judge will note that. The judge will know that you had replied already, and then you reiterated that same thing. That means that you do not have any research material and you were not having a presence of mind while answering the question. That is the most important aspect. So do not keep on repeating your issues just to protract your timing for a particular issue. And if a judge asks you, don't think that like you have gotten thrown off balance. Always have like a backup plan. What I refer to it is lightning rod argument. So when I had the workshop for the moot court in my first semester, we there was this advocate that came and she said that in the Navteet Singh Johar judgment, advocate Arundhati Karju was actually arguing about the case first. I'll get to that, Abhishek. Just give me a second. So she was arguing on the basis of international treaties, and the judges did not look convinced by the expressions on their face. So then she deviated from her plan, and then she came out with this lightning rod argument regarding the jurisdiction of India and the jurisprudence, the constitutional jurisprudence, and the constitutional morality of equality regarding LGBTQ community and everything. And that seemed to really resonate with the judges. And that really helped, I think, triumph in the judgment, triumph in the case, actually. So always have like that backup plan whenever you are, thrown into a corner, because you know what the other side is going to say. So have like a reply to that. Okay.
What is this lightning rod argument? Can
So
you
okay, so
please?
for example, so for example, let's say that you know that the other side is going to raise the fact that there were like, okay, for your FIM ka thing, okay, the because of the husband, like let's say that you have said that husband should also be implicated in this particular thing, okay, and you're saying that because husband was present, husband did not help and all that and everything, and the judges say that but there's no mens rea, there's no actus reus, how is the husband responsible for this particular thing? So at that particular point of time you're not ready, right? Because all your argument was based on the fact that the husband was present over there and he was a silent observer. Okay, so at that time you have to prove on the basis of, let's say, just by being part of the crowd, that his silence was part of participation. So his silence as consent for abuse against his wife has to be proven to the court. Okay, so that becomes a lightning rod argument at that particular point of time, because you were arguing only as a part that husband was part of the family and that's why he should be implicated. And now you're arguing based on the fact that husband was silent and he was seeing the abuse, he did not help her, and that's why he should be implicated. He was a mere silent observer. And so lightning rod argument is basically like this backup plan that you have always in order to secure your arguments no matter what happens against a judge. Okay, getting back to Abhishek, but can you please explain again, like how to research cases on the basis of issues or arguments? Okay, so okay, I'll show you the FIM ka thing. Okay, wait, how you can research on that. Let me just share the screen now. Okay, where's the FIM? Where is the FIM? Oh yeah, there we go. Notice and handbook. Okay. I hope everyone can see my screen now.
Yes, ma'am.
Okay, perfect. So statement of problem, right? They graduated from prestigious college. Both of them were good in studies. attended lectures. Now, see, the thing is this, okay? Both of them were good in studies. This can be used against you largely for the fact that she was knowledgeable, right? If you have seen the cases of, if you have seen a lot of IPC cases, like for example, even that Dorai Rajan case, have you read the IPC kidnapping case, the first case in kidnapping?
No, ma'am.
Okay, so
Not
when you read
really.
the first case in kidnapping, the judge basically says that because she was educated and she was a city girl and not an innocent, naive village girl, so she had like her wits about her and she knew what she was doing, and it was not a kidnap. Like the guy did not kidnap her; she went with him, with her own will and understanding regarding that. So this can be used against you if you're arguing from, let's say, the woman's side, that she knew what was happening and still she kept on being with him and she condoned his acts and everything. So that can be used against you. So be ready for that. So we have cases on that where the court has referred to the fact that just a good understanding will not help. Like for example, the education is not a reflection of how a person has adjudged his life abilities and all that. So have judgments regarding that, or have judgments regarding that education is not a reflection of your mental maturity and everything. And he also had good education, so he also knew how to protect his wife, and because he did not, hence we are going against him, right? So if the judge asks you, but she was very well educated, she knew what was happening, she condoned his acts, then you can very well just retort with the fact saying that but your lordship, her husband was also very well educated and he knew what was happening, and he still kept on letting the abuse be against the wife, and the wife of course felt cornered because of the mere fact that there was no one speaking up for her and she was alone and she was lonely, and it's completely understandable, it's completely humane to feel weak in those circumstances and feel victimized in those circumstances, right? So you need to have those arguments back, right? So you need to note down the very details of the moot proposition, okay? Now, with the, okay, then we go, for example, um, she succumbed to the desire of her father and eventually decided to marry Danish Sarkar. Okay, so this can show you how she was career oriented and how he ruined her career aspirations. Okay, this fact comes into play at that particular point of time. Okay, for this you can use the divorce case that was fuck, I can't remember it right now. It's not coming. But even if it's not coming to me, it should come to you because it's your proposition. And I've not researched anything on it. And I'm sure that you have researched a lot on it. And I am just diddly squat in my knowledge regarding this. But yeah, so she like you have to go through this. You have to make the court understand that her career aspirations were sacrificed and her husband did not reiterate in that. Okay. The marriage was solemnized. This Hindu rights, purchasing. So these are all the dowry details. Went to her sasural at her residing with the parent-in-law, residential, demoralized her and humiliated her. Okay. Now, by passing sarcastic remarks on her by saying that her parents have not given sufficient gifts. Broke down into tears, cried for the whole night. She never expressed such type of treatment. However, the next day, her husband consoled her, saying that she should not respond to his parents, right? So now the thing is that he consoled her and he helped her out, right? Okay. So that means that he was on her side. You can't implicate the husband. Like this fact can also go against you. So all I'm saying is that detect the facts that can go against you when you're making your case, and then research on those facts first. Because when you research on those facts first, then you know exactly what you'll be asked and what you have to say then, and what exactly should your cases say. So when you know what you don't have to say, it's at that time that you start researching for what you do have to say. All right, that really helps you out, because researching on all these cases will help you out in finding all the nitty gritties and all the finer details of a particular case, and they will really help you in highlighting like exactly what you're against.
Excuse me,
So
ma'am.
yeah.
Actually, ma'am, basic question was that like that. Do we have to like establish our argument on like every argument on judicial precedent, or like we can just go ahead and straight for?
It is proof that if the parents have humiliated and have demoralized the wife, the husband by vicarious liability is also responsible for humiliating and demoralizing her. when he's staying silent. So you have to have the judicial precedents. Otherwise, what are you arguing on the basis of that? After that, it's only a debate, no? The mere fact that you're providing arguments in front of a court means that you have judicial precedents behind you. That's
Right.
it.
And ma'am, the second question was that how to find those judicial precedents. Like suppose in the previous slide you're showing that the cruelty. Like suppose the appellant is arguing that the mere sarcasm can amount to cruelty under section 304B, and
Yes.
respondents are arguing that mere sarcasm cannot amount to cruelty under section 304B.
Okay.
But my question is this, ma'am, how do we find on the cases for
Okay.
this
See,
argument?
I'll tell you something. Okay. Now I'm not going to show you this because I think you should do this on your own. So
No, ma'am.
if you have on
The
your
technical aspect is that, ma'am, I just can't figure out how to use those websites actually on to use those websites
Okay.
with Kanun and Manupatra like that.
Okay, so let me show you something. How to use it for that thing. Okay, so now the thing is that when you're saying that mere sarcasm will not qualify as cruelty, that
No,
means
ma'am,
that
I'm saying that suppose we have an argument in our mind, like this is our argument, but how to find precedent for that?
okay.
Whatever the argument it is, like
All right.
it can be anything.
So see, the thing is that when you have cruelty, when you're contesting for cruelty, and I believe that you might be contesting for cruelty, of course, on this basis, then the whole contentious aspect is the sarcasm that was used. Okay, how can sarcasm be enough? So at that time, you find the cases where elements of mental cruelty has been given. Okay, I believe there was a very recent live law case where it was mentioned that that a wife demeaning the husband is enough to form is enough for mental cruelty, and divorce can be granted. Okay, so this has been cited in 272. Okay, yeah. So you refer to, first of all, Supreme Court cases. You start with Supreme Court cases because, as you can see, 3,873 cases, you can't physically go through 3,874.
But in some cases, High Court and Supreme Court, some judgment are there that sometime only sarcasm, mere words is not come under the cruelty and harassment.
Okay, so I'll tell you something. Okay, so that's
And-
why I was telling you note down the quorum and the bench. Okay, so if you have a judgment by a bench, which is like 5 judges bench, okay, or a 3 judges bench, then naturally, if there is any high court judgment on that, it will be overruled, na? Like understand this aspect that there is Supreme Court has said that sarcasm is mental cruelty. Like let's go with that hypothetical. Okay, that there is a Supreme Court judgment which has said that sarcasm is mental cruelty. Okay, and you have found the judgment. Okay, and Supreme Court has said that these are the elements of mental cruelty, and because sarcasm fits into these elements, hence it is mental cruelty. Let's go with that. Okay. Then there's a High Court judgment which says, like, let's say High Court of Guwahati has said that sarcasm is not mental cruelty. Okay, and the judge ends up saying that to you that there's a Guwahati High Court judgment which says that
Isn't
it's
it
not
binding
mental
under 141 of the Constitution, ma'am?
Yeah, exactly. That's what I'm saying, right? If you find this, that's why I'm saying begin with the Supreme Court judgment itself, okay, where the elements are given. Now, the thing is that you also have to note down the dates, okay? If there's a 1993 judgment which says that sarcasm is not mental cruelty by the Supreme Court, but there's a 2006 judgment where the Supreme Court says that sarcasm is a mental cruelty ka thing, okay? The 2006 judgment will triumph the 1993 judgment. The recent judgment of Supreme Court are considered and not the later judgments, until and unless the later judgments are by a higher member bench. Okay, so if the 1993 judgment is by a 5-judge bench and 2006 judgment is by a 3-judge bench, naturally the 1993 judgment will triumph over the 3-judge bench. Okay, but if, let's say, the 2006, and this is where your inversion test comes, and this is why I had told you that inversion test will be a very important thing for you. If the 2006 judgment ka facts and 1993 judgments ka facts are completely different from each other, okay, like for example in 1993 there was also an element of physical cruelty, in 2006 there was no element of physical cruelty, okay, then naturally you can always contest that your lordship, in that particular case there was an element of physical cruelty, and that's why we are saying that this particular case is completely different from that case. Okay, now the thing is, that's why I said you have to research on what you don't have to do and what you don't have to say, and then you start the research with what you do have to say. Because when you realize what you don't have to say, you will find all the cases that can go against you from the Supreme Court only. Don't go haywire and start searching every court ka judgment. That will not help your case. That will only overburden you. That will really not help you with the research also. Okay. So there are 420 cases now. Okay. And we start from, let's say, 2002 judgments. And then we start finding the cited by, like, let's say there was a 148 times it has been cited. So naturally, this is a widely recognized judgment. Then we find out the quorum for this judgment, who, like, how many judges were sitting on the bench. This was a division bench because there were 2 judges. Okay, and then DP Mahopatra has written this judgment. So you read each and everything of it. You know the judgment by heart. And any judgment that it refers to, then you read that judgment also. Like, for example, this refers to Dastani versus Dastane. Okay, it refers to Savitri Pandey versus Premchandra Pandey. So know all these cases, why these cases have been referred, why these cases have been cited. Know that fact, have that understanding inside you. And if it, like, for example, even if a judge just throws a random case at you that you have not researched at all, that you have no understanding of it, then you can always say that, Your Lordship, those two cases might be standing distinct, because in this case, Dasani versus Dastani, which is the current ongoing landmark precedent, has been reaffirmed. Naturally, any case that reaffirms an older case, which is well-known landmark case, will stand as the as a distinct case. So that really, so that's why I said go through the judgments that have been cited inside the judgment, because then you'll realize what are the elements of it, and how do you exactly, and what are the actual fundamentals of it. How has a court interpreted judgment, finer details of it. Moreover, also go to the research papers ka thing. Like, for example, we
Samriddhi,
refer to a scholar paper. Yeah.
But these judgments are like very, very long. So do we need to read all of that judgment?
Yes, ma'am.
Oh.
And, like, is there any way to filter out all of this so that we can have end up in like 2-3 judgments at best?
1, 2, 3. Oh my God, no. See, the thing is that you're a lawyer. You're going to be a lawyer, sorry. You're a law student right now. So reading each and everything is mandatory for you. And it's better that the sooner you inculcate the habit of reading, the better it will be for you. Mainly because there are a lot of times when an obiter dicta is misinterpreted as a ratio. And like, I'll give you a simple example. You know about Maneka Gandhi versus Union of India, right?
Yeah, a little bit.
Yes, ma'am.
Yeah.
ma'am. Yes,
So
ma'am.
you know that facts of the case are Maneka Gandhi had criticized the Janata Party government, and then she was going on a foreign trip, and she was absconded at the airport, and her passport was her passport was taken away. Then she filed a case, okay, and the case became like this whole like very extremely important case and everything, and was like, oh my God, matlab liberty का तो इतना expand कर दिया है. It's such an amazing precedent, and which it is. Maneka Gandhi is an extremely beautiful case to read. Okay, do you know by the end that you finally, when you read the case, that Maneka Gandhi did not get the relief that she wanted. Maneka Gandhi was not given her passport back.
Yes,
So
ma'am.
when you read that, you get to know that, and it will be because if you read the like first 5-10 pages of the judgment, you are like, of course, court itna detail mein ja raha hai, and we passport de diya hoga. But nahi diya. That's the whole point of reading a judgment. That you get to that even if someone says that if a passport has been compounded, and then then the court does say that, in Maneka Gandhi, whatever you're advocating for on behalf of government was ruled upon and then was adjudged upon and everything, then you can always say, but Your Lordship, in Maneka Gandhi, her passport was not given back to her. So we are standing at the right side only. It's perfectly all right for us to do what we are doing right now. So that's why you read the judgments. I am telling you, please, they inculcate that habit of reading. If you refer to only 1-2 cases, trust me, you're going to trip up, and the judges are going to have you by your collars, and they are going to give you hypotheticals which are actually based on cases, and you have not read those cases, so you're not going to know the answers. And see, the major distinction between you and a common debater, a common man, is that you know the law. And the only way that you know the law is by reading the law. So if you don't know the law, if you don't read the law, how can you go ahead and call yourself a law student? So I believe it will be very beneficial if you just go ahead with a lot of reading habit inculcated. Start with like small incremental changes in your schedule, and then I think you can inculcate that.
I have a question.
Ma'am.
Ma'am, there was a peculiar case in which sarcasm as a mode of cruelty was expressed. How do we find such cases? A particular legal issue is raised on that case. How do
Okay,
we
so
find-
I'll tell you something. Nirupam, see, the thing that happens is when you're given a moot court proposition, you are given that moot court proposition for the simple fact that that particular factual matrix has never happened before. Okay, so for example, if your moot court proposition has fact A, B, C, D referred in it, there's a very highly 95-98% chance that fact A would have been considered in some other case, fact B would have been considered in some other case, and fact C and D simultaneously would have been considered in some other case. Okay, how you bind all those four cases together and how you say that all those four cases are actually applicable to my particular scenario and how those all four cases justify the remedy that I'm seeking for is upon your drafting skill that you have to learn. Okay, and then that you have to inculcate. See, you have to participate in more and more moot courts. Only then you will realize how to finally find out all the intricacies of a moot court proposition, how to find out a certain obiter dicta that becomes binding on a high court of a Supreme Court, and how to find out how to extract the ratio. For the first year of my law faculty time, I genuinely did not know how to differentiate between ratio and obiter dicta. Now I know that because I've read that many judgments, and that's why I can like finally find out. And even still, I am a bit blurry regarding what exactly will be an obiter dicta and what exactly will be a ratio, because sometimes judgments are worded in that manner. You can't help it. You can't help finding that thing. So I think all I can say is that it's just practice, 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 practice. The other thing is that, for example, right now this particular case refers to only sarcasm. There might be several other cases where it might be regarding letters and where it might be regarding outright actions. So you can take those judgments and then you can refer to them. That's why your research has to be very, 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 very deep. Anything else?
Yes, ma'am. Actually, ma'am,
Yeah.
regarding the proposition, like, do we have to limit ourselves regarding the issues in the proposition? Do we have to limit ourselves to the issues already provided in the proposition, or we can raise our own issues separately? Like
No,
in
you
this-
can also raise your own issue separately. Like I don't think there's ever a limitation on that. So you have to read the instructions properly. Okay, so in any moot court competition that I have come across, the moot court proposition clearly refers to an instruction that says that you have been given two issues and you can frame as many issues as you like besides these two issues. But these two issues are mandatory issues. So whatever issues that you are given in a moot court proposition are mandatory issues that have to be argued no matter what happens. And any issue besides that can also be raised. So whatever issues that you are given in this particular moot court proposition, you have to argue them. If on top of those issues you want to argue some more, then you can, of course, add them however you like. Anything else?
Ma'am, can you repeat the name of the website?
Which
Again?
website?
इंडियन कानून और मनुपात्र के अलावा जो आपने कहा था.
Okay, so I'll tell you, I'll write it in the chat box. Okay, so there is LibGen for books, pirated books. There is Sci-Hub for research papers. Then there is Indian Kanun. There is Supreme Court Observer. Sorry, yeah. Observer. And what else? And then there are High Court and Supreme Court websites that you can refer to individually at your own will. So all these are given in the chat box now. These are largely the websites that you can refer to. And you can also search up the concept of the legal proposition that you're arguing on Google Scholar. So you can always go to Google Scholar and you can type sarcasm, mental cruelty, divorce, England or USA, and then take inspiration from there, because their jurisprudence is heavily evolved than ours. So naturally, you will find enough cases over there. And when you read the research papers, first to read the abstract. Abstract is like the small little paragraph that is given in the start of the paper. So read the abstract if you think that this case is relevant to you, because abstract is like a summary of the whole paper. So read the abstract if you think that this is relevant to you, refer to it. And then when you read the paper, there will be footnotes. And in the footnotes, there'll be cases cited. So refer to those cases, search what those cases are saying, and if those cases are relevant or not. That's how I find my international cases, at least, because I don't have any Westlaw, LexisNexis given by the college. So naturally, I go for the research papers and then I refer it from there. Anything else?
Thank you, ma'am. One more question.
Ma'am, I have a contention.
Yeah.
Okay, so how would you delineate the jurisdiction as to under which court this case should be tried? Like in this particular case, the first class magistrate has taken the cognizance under section 26A, clause A, subsection 3 of the CRPC, whereby the penals are provided 304 of IPC 498A. So, I just wish to know whether this should be trialed in the session court or under the jurisdiction of the first class magistrate itself, because that we have to mention it, right? So I was very confused. What should be mentioned?
So because there's IPC involved in this matter, do you have your criminal manual beside you?
Yes, ma'am.
So when you open the criminal manual, you open the CRPC section, okay? You open the IPC section, and right underneath the IPC section, there'll be like this small comment which says bailable, non-cognizable, cognizable, triable by magistrate and all, right? So if it's triable by magistrate, it means it's triable by first class magistrate also. And if it says that it's triable by sessions judge, and like if it mentions a certain qualification, then actually it means that the first class magistrate has to refer to the sessions judge, naturally, because it's not under his jurisdiction. It's not.
Okay, so irrespective of the fact that first class magistrate is taking the cognizance, if the penal falls.
I'll tell you something. Okay, cognizance does not decide the jurisdiction. Cognizance is basically that he is aware that there's this matter that exists, and he thinks that there is some gravity in the evidence that has been presented, and based on that gravity of the evidence, this case has to be considered further. Okay, after the charge sheet has been filed, after all the stuff has been done, and he has taken the final cognizance, then he will decide if the case, if the sections that have been charged in this particular case actually stand to merit or they don't stand at all, based on the final evidence that has been collected. Okay, and then he will decide if all those sections are fulfilled or not, and if any more sections needs to be added or not. Okay, so for example, like in this particular case, if marital rape would have happened or if something else would have happened, like for example, let's say grievous hurt or something would have happened, then he would include those cases also. He would include that charge also. He would include that section also, and then he will remit the case to sessions judge. He'll be like, because after adding this charge, after adding this section, it has gone out of my jurisdiction. So please, you take the case now. So cognizance is basically that he's aware that there is a judicial application of mind. Cognizance does not refer to anything more than that. That's all that cognizance is. So even if he has taken the cognizance, you can always argue that because it falls out of your jurisdiction legally, you should refer it to the sessions judge. That's all that it is. Nothing more than that.
Ma'am, if to join the society in the second semester, will we have to go through the same process, or will it be like according to vacancies in the society?
No. So Rahat, what happens is that every year there are 7 posts that are opened no matter what happens, because 7 people are selected every year, and their membership expires at the end of that year. So when you join this year, your membership will expire by the end of the next year.
So we can then try in the third semester, not in the second semester.
No, you can try in the second semester also. You can try each. You can try in the third. I thought you were saying second year. I'm sorry. So you can try in the third semester for sure. It will happen every year. FIM happens every year. So it's fair.
Just one more question.
Yeah.
Now, there is an evidence, very factual, that the police has perhaps exonerated every accused in this particular case already before taking the cognizance of this first class magistrate. Isn't it a valid? They in their closure report, they have clearly exonerated the accused, that there are no substantial evidence against them to substantiate the charges alleged by that woman's father. So isn't it, that kind of evidence whereby I can say that, the police has already exonerated, then why should we go for a trial?
I'll tell you 2 things, because I really don't want to sound biased in this particular instance. So what happens is that when a closure report has been filed by the police, that means that the police is unable to find any more evidence in this case. Okay. And the police thinks that whatever they are recommending, that case should be closed, and it should not stand anymore, and there should not be any more investigation. Okay, so once the police has filed the closure report and the closure report goes to the magistrate or the judge, whoever is there, then this is protocol basically. This is not exactly written in CRPC, but this is protocol that a notice is sent to the victim or whoever was the complainant. Okay, a notice is sent saying that, listen, a closure report has been filed, and if you have any evidence that can be brought to light that can substantiate the charges further or that can help the investigation further, please come ahead, please come forth and argue for the opposition of the closure report. Okay. After the opposition has given their argument, after the complainant has given their argument saying that no closure report should not be done, further investigation is required. The magistrate or the judge will decide, the competent judge will decide if the closure report should be acted upon or not. Moreover, when the closure report is submitted, the judge still has a discretion whether to finally close the report or not. I'll give you like a very well-known example. Have you heard of the Talwar case that happened, Arushi Talwar?
Yes, ma'am.
So in Talwar case, the police had actually given the closure report saying that, listen, we are unable to find any more evidence, so please close the case. Okay. And the parents said that no further investigation is required. Okay, the case should not be closed. The sessions judge had actually disregarded both of those arguments because the parents had argued on like some substantial grounds A, B, C. The police had argued on substantial grounds D, E, F that it should be closed. And the judge actually said that no, actually what should be done is that case is ready for trial. So I'm not closing the report, neither I'm asking for further investigation. I am initiating the trial from now on only. No more further investigation. So that happened. So that discretion is with the judge. That judge can do whatever he wants after the closure report has been submitted. That's completely up to him. He can ask the case to go straight to trial. He can ask for further investigation. The complainant can be given an opportunity because it's principles of natural justice, right? They have to be given a chance. They are the ones who filed the case in the first place. So that's how the process for a closure report happens. Take from it what you will, because I'm not going to.
So basically, ma'am, I was just referring to whether this can substantiate if I am, taking part inside of this particular man. So
Yeah.
wouldn't
This
it
can be
like give a gravitas? And there is also, I shouldn't disclose the facts because everyone else would follow that. Because there was a statement from the girl itself that, there was this, that I was very completely free. Oh, she is a
See, this is the exact reason why I was not willing to discuss FIM over here. But it's all
Ma'am,
right.
basically, I can
Yes,
flip
we
the
can.
side too. I just want people to join into this particular. So that. Thank you, ma'am.
I completely understand that. So yeah, you can always argue for the closure report. You can argue against the closure report. Is all I'm saying. That's it. Period.
So basically, I can. This is a
Yes, you
substantial.
can.
Okay, thank you, ma'am.
There will be substantial cases on the basis for this particular
Then I
line
won
of
the gas,
argument.
ma'am.
So, yeah.
And there
Anything
is
else?
last statement from the girl side is also there.
Yeah, of course there is something. The thing is that there will be enough material from both the sides. Then this is why I never think that there is a good or bad side to argue a moot court proposition, for a simple reason being that there are enough evidences, there are enough facts to go on in both the sides. There will always be one damning fact for the appellant. There will always be one damning fact for the respondent. So what do you do is that you
Yes,
upon
ma'am.
research.
It's very convoluted. In fact, the girl's statement, in
This is-
fact, when she says that everything is fine, but I was
Everything is
just
fine. My
distressed.
husband is too good. It's
Yeah,
just
ma'am.
a
No,
daily routine case.
Sonali, not that point, ma'am. We have seen that border movie. उसमें बोलते हैं ना कि like घर पे सब ठीक है, तो बोलते हैं हाँ सब ठीक है, बस गाय के 2 पैर टूट गए. अम्मा ठीक है, हाँ अम्मा तो बहुत ठीक है, बस पैर में फ्रैक्चर हो गया. So similarly, the girl's statement is that I was fine. It's completely fine. It's very much like into a married life, but I was distressed. I was very much in pain. सब
Yeah,
कुछ
see,
ठीक था. Yeah, ma'am.
that's exactly where you go ahead with. Nowadays, if
His husband is supportive. His in-laws is not that supportive, but his husband is supportive. In their honeymoon case, we can see how much his husband is supportive to his. उसने जो कसम खा रखी थी उसमें भी उसका husband कितना supportive था. उसने बाद में भी काफी support दिखाया है. तो husband की क्या गलती है उसमें? उसने suicide कर लिया.
Sonali and Akhil, I love your passion for this, but I am not your lordship currently. Neither I am anyone to adjudge the case. But yes, anyone can go ahead with any line of argument. Please don't
Thank you,
feel
ma'am.
that कि मतलब husband की side ही बनती है, wife की side नहीं बनती है. When I took part in my FIM, everyone was taking. So there was a case of a patient and a doctor, and it was a clear case that medical negligence has happened on the side of the doctor. And the patient has suffered and all that stuff and everything. And the patient has done some defamation against the doctor. So no one was arguing for the doctor. Everyone had gone for the patient. Everyone felt that this is the easier side to argue. But I was like, no, doctor की क्या गलती थी? उसने तो अपना पूरा काम करने की कोशिश की ना. Like there was an effort made on his part. There was an initiative on his part to fulfill his duty and everything. So, take. I would recommend taking
Ma'am.
the tough side.
दिस केस इज टू गुड. इधर तो दोनों के पास, दोनों ही केस में बोलने के लिए किसी ना किसी के पास कुछ ना कुछ रहेगा.
Yeah, exactly. And it's always the case.
Ma'am, can we have a poll?
Yeah, no, let's not have a poll, Akhil. Let's not do an exit poll right now and skew the favor of the people in any circumstances whatsoever. I'm really against election tampering. I will let you know. Yes, go ahead.
Ma'am, I have a doubt regarding the fair closure report. So
Yeah.
in this report, ma'am, it is written that the section provided is 406 read with 34. But according to me, in our case, it should be 306 read with 34. So because 406 is criminal breach of conduct. So it has nothing to do with that, I think.
See,
So it should be, yes, ma'am.
once again, that is completely up to you to argue, okay? You might feel like there is this particular section that is applicable. Someone else might feel that no, this section is completely not applicable, and that's completely up to you to argue. I'm not going to.
I'm just asking that is it written by mistake, or should we consider 306 because 306 is abatement to suicide, which exactly in the questions, for example, in the final when the court.
Did you not have time to ask for clarifications from the organizers?
Ma'am, I added the question to via mail, but I have not gotten response yet.
So I think you should call someone from the Moot Court committee, no?
Okay.
You can always call. I think there's a number given on the Moot Court.
Ma'am, I don't think so. There is any charge in this particular case under
Of
IPC
course, Akhil, you don't think
306.
there is. Akhil, you don't think there's any charge regardless of the matter. So please, I'm not considering your opinion in this. But Tushar, yeah, you can ask. You can call the organizers and you can ask for clarification regarding this. You can ask if it's a typo or if it's deliberately inserted. So don't worry. Okay. So is there anything else? I believe
What
that's
is
it.
the process of joining the?
Ma'am, if you can share the
Okay, wait, one by one. So we'll start with Nirupam. Go ahead.
Ma'am, what's the process of joining the Moot Court Society?
Okay, so Nirupam, the process is simple. You go for the FIM, and if you make it to the top 7, then you are in the Moot Court Society. If you don't make it to the top 7, you're not in the Moot Court Society. And then if you're not in the Moot Court Society, then you can still submit your internal memos for any Moot Court competition that you want to take part in. That is notified via the Facebook page of the society. So it's just as simple as that. FIM is your way to entry in the society. Yes, Sonali, go ahead.
Ma'am, in this case, if we have to just fight for the man, for the husband, not for his family, is it possible?
I think that will be given in your instructions and your mood proposition that you're representing this particular person. So I think that is given in the proposition. I think you should read it a bit more closely and you'll get an idea.
Because in police case or in some case, the husband is acquittal, but मतलब family के लिए गलत बोला गया था. But जब magistrate ने cognize लिया तो उसने मतलब सबको ही जमा कर दिया.
See, Sonali, that happens sometimes, and sometimes one lawyer represents the whole family. So I think you just need to look into the Moot Court proposition to understand what exactly is being said and who exactly you have to represent.
A particular individual.
What, Nirupam? I didn't get you.
I'm saying that the question she's asking that whether only the husband or the whole family. So the sections they are framed are for the whole family. It is not for any particular individual. कि ये अच्छा है या बुरा है.
Yes, yeah, exactly. Yeah. So yeah. So if it's for the whole family, then you naturally have to represent the whole family. It's as simple as that. Yes, Akhil, do you have anything else to say?
Excuse me, ma'am.
Thank you, ma'am.
Yes, go ahead, Divyanshu.
Can you please shed some more light on about the court demeanor and etiquettes, basically how to address the judge?
So regarding that, what I'll do is that I'll send you some readings or documents I believe I have for that, because see, the thing is it's completely simple actually, and I was actually thinking of having like this really mini 5 to 10 minutes wala session just for that, where like one or few people can could have come forward and volunteered to be to argue for a side, and then I could have told you that, listen, you have to say this, you have to say that, and everything. Like, for example, when you start, you have to say the council seeks permission. Like, okay, yeah. So the first thing is that you never refer to yourself in personal pronouns. No I, we, our, us, nothing like that. You refer to yourself as the council, nothing else. Okay. So the council would beg to differ. The council agrees with your lordship. The council would like to highlight this fact and all that. So it's always you are the council. You refer to yourself as the council. Third person, nothing more than that. That's the first thing that you have to keep in mind. Second thing that you have to keep in mind is that you have to seek permission from the bench whether to address them as your lordship or as your ladyship, collectively and individually. That's the first thing that you do. Second thing is, you ask, if you're going as the appellant or if you're going as a petitioner, you ask for permission. You ask whether the bench is well apprised of the facts or not, and if you can go straight to the arguments. The bench will answer accordingly that no, you can go straight to the arguments. Okay. Then you introduce that the council is going to argue on these many issues. And beginning with the first issue, the council has these elements to prove, and then you begin with your final arguments. Okay. What I'll do is that I'll share whatever readings I have on the court etiquettes with Fuzel, and Fuzel can just forward it all to you. So that can work, I believe.
Sure. Thank you.
No problem, Divyanshu. Okay, if I think you are done with your questions, do you have anything else to say, Sanju?
Ma'am, how would we able to score good in oral round? Like, what are the
So that is completely up to you, Sanju. So sometimes what happens is that you get asked very basic questions, like you will get asked, what are the elements of condemnation? Are those elements fulfilled in this case? Where were those elements established first in Indian jurisprudence? So like you'll get asked all those questions and everything. Like sometimes you get asked very basic questions. Sometimes the judges might ask you very tricky questions. Sometimes the judges might give you like a very complex hypothetical. So that really depends upon how well you. So two things that you have to understand: how well you know the facts and how well you know the law. Okay. Because the judges would have read the memo, not the memo, but the factual matrix, just like 5-10 minutes before coming to judge you. Okay. So they would have just read it and they would have been like, oh, okay, इसमें ये divorce का है, इसमें cruelty का बनेगा, इसमें ये बनेगा, okay, इसके ऊपर argument होगा, ठीक है? So naturally they would not have read it in much detail. But you, having spent time with it for like almost a month now, have gone through it in excruciating detail, like piece by piece, right? So you know it left, right, and center. Similarly, with your law, you should know the very fundamentals of the law that you're arguing. So if you're arguing on the basis of, let's say, Dastani versus Dastani, and how Dastani versus Dastani is applicable over here because, you know, certain elements are fulfilled of Dastani's ratio, then you should know how the condemnation elements have actually evolved ever since Dastani was given in 1975. So that is completely up to your knowledge, and nothing else can save you in oral arguments. So those are the only two things that you have to consider: is how well aware you are of the facts and how well aware are you of the law and the basics of the law, the fundamentals of it. That's the only thing.
Okay, ma'am. Thank you, ma'am.
No problem. And there's no other jaddi booty that you can use to score in oral arguments. I wish I could give you that. Yeah.
And what's last question, because I don't know this. Do we have to file separately for bail, or do we have to contend separately, or in the same?
No, you have to contend in the same thing.
Same memorial may.
Yes. You have to contend for it in the same memorial. Because there's only one memorial that you'll make, no? So each and every issue has to be in that particular memorial only, and nowhere else.
That would cover in pre, I think.
Yeah. So in the prayer, you cover the remedy that you're seeking. In the arguments advance, you cover the issues that you are covering, right? So, for example, if you're covering the issue that this charge should not be on this person A, and they should be given bail, and all the charges must be dropped. So you highlight the exact remedy that you want from the court. If you do not give a remedy, if you do not ask for a remedy, then the court will not give the remedy. It's as simple as that. Moreover, no one really cares about the prayer. No one really reads the prayer. And also, by the way, once you are done with the arguments, and once your court master tells you that your time is up, please seek permission from the bench to read the pair. It just and you can just speed through the pair. You can just rap through the pair, and no one really care. But it just looks that you have you have wrapped your arguments completely. There's nothing else left.
Thank you.
Thank you, ma'am.
No problem. Now I believe that's it. Is anything else left?
डेकोरेशन कितनी करनी है?
Decoration for what? खुद की या मेमो की?
नहीं, बॉर्डर मेमोरियल के और लाइन वगैरह.
See, it's not decoration exactly, but you have to format like a typical format that you would have been given, like Times New Roman, 12, line spacing 1.5. वो तो करना ही पड़ेगा. And then there is the color of the front page. That's all that matters. Your color of the front page, which is red or blue, depending upon whether you're respondent or applicant, petitioner, and all that. And that it should be Times New Roman, size 10, and 1.5 line spacing. For your footnotes, it always is Times New Roman, size 10. For the main body, it's size 12, and for the footnotes, it's size 10. And the line spacing for footnotes usually is 1 or 1.15. So that's all that you need to know about that. Nothing more.
Are borders allowed, and can I change the size of font on the title page?
You can change the size of the font on the title page. That would not matter much. Borders, you can inculcate borders. That really doesn't matter.
Thank you.
So that's completely up to you whether you want to include it or not.
Ma'am, one last question.
Yes, go ahead, Akhil.
So I was kind of having an ambivalence of feeling. Like, suppose I have two questions. Like, suppose that I cannot make it through this FIM, and what would be the distinction of being into this Moot society and not being in the part of this in the first years? B, how many Moots competitions we can expect in our 3-year career?
Okay.
That's all.
So okay. So first thing, what is the distinction between being in Moot society and being not in Moot society? According to me, because I've been in both the positions now through my 2 years, being in Moot society just makes you feel like exclusive part of the club. That's nothing more. And you get to take part in the executive side of the decision making. And you get to witness the internals that happens, right? So when people are arguing for the internals to be eligible for participation and represent their institution, so that's something that you can witness being a part of the MCS. Being not part of the MCS is more of a freeing job because you don't have to worry about anything else. You just have to worry about your own internal and your own memo, and you just hope to make it through. So there's not really much of a difference in LC1 because it's an open society. The only reason that people make it for take part in FIM, or at least the only reason that I did, was that I just wanted to see whether I had the caliber for mooting and advocacy or not, oral advocacy or not. And I realized that I really love it, and I really love how grilling the whole session is and how much detailed research I have to do. So that's why I went ahead with it and I took part in it and I was selected. That's the end of the story, actually. Nothing more than that. And B, how many moots you can take part in, that really depends upon how many moots are you aware of from the Facebook page and how many moots are up to your area of law. So you can take part in as many moots as you want to. Ideal number for you by the end of your 3rd year should be somewhere around 6 to 8 minimum. And that would really, because see, the first 3 moot court competitions, you are still figuring out what is happening, what is going on and all that. And by the 4th, you realize that, okay, cool, I know how to nail this now. I know how to ace this. So that's why I would really encourage you to take part in like any random first 2-3 moots and be a researcher. Why being a researcher? So I'm not going to say that you should aim for the researcher, but you should take part in a moot, and even if you're not selected for the speaker, just like stick as a researcher, like as a very good researcher. And you should know the factual metrics and the law inside out on that particular proposition. So because you will see your speakers arguing and you will see your speakers speaking and defending. So you'll get a basic idea regarding how you should be arguing and how you should be defending your stance. Second thing is, if you're selected as a speaker on your first time, then perfect, nothing more than that. Because arguing your case is more of a learning experience, is an extremely well endowed learning experience than ever studying law on that behalf. So I did not learn about bail in my third semester as much as in my second semester as much as I learned about bail during my third semester when I was preparing for KK Luthra moot court competition. So that's only that I would say. Minimum, I hope that you take part in 6 to 8, but there are some people who do take part in only 3 or 4 moot court competitions. So that's it.
And ma'am, for like whatever, so I haven't started yet. So like,
Okay.
and we have to, I think the last date is 15. So is there any point, like if I start?
Okay, Raj, so I'll make a very honest confession, and this will not really look good on my part, but let me come clean with you. So I was actually not going to take part in the FIM at all. I was really very much in a predicament. And I had called up a friend of mine, a dear friend of mine, saying that, listen, and the last date was, let's say, 7th, and I called up my friend on 5th, saying that, listen, I don't want to take part in it. I don't see the point in taking part. There'll be only executive functions. Like, what will happen, and like, what will I get to witness? There's nothing in it. Like, what is it going? Like, how are they going to judge me? And it's only one side. It actually won't. So he really convinced me that, listen, you have the skill for it, as far as I'm aware. So just go ahead and just try it out. It'll be like a good learning experience, even if you don't make it. I was like, okay, cool, fine. So I started preparation a day ago. Okay, by the way, not a good precedent for you guys to follow, but I'm just being honest. And even if you start today and the last date is 15th, you can still have a good memo and prepare it.
All right. Thank you.
Yeah, no problem, Rahat. So anything else besides that?
How good should our be?
Nirupam, I didn't understand your question.
Like there could be many people competing for the same 70.
Nirupam, can you just write your question in the chat box, because I'm really not understanding your question at all. Fuzel, can you mute yourself, please? Fuzel? Thank you. Nirupam, it'll be really great if you can just...
Audible now? Am I audible now?
Yeah, you can you are audible now.
Ma'am, I'm saying how good our memo should be to be selected in the FYMs, because
I don't think there's a qualifying thing for the memo in the FIM, but I think your memo should have like a basic level of research done. So, for example, you should have landmark cases substantiated by the cases which have reformed those landmark cases very recently. So that will span over to like 20-25 cases at the very least. You should refer to the statutes extensively. You should refer to like a couple of research papers. That should be it with regard to your research. And moreover, your arguments advanced should be very well composed, I believe. Yeah. So just be very exact and definite with what you want. See, first you have to be clear in your own head regarding if you are convinced regarding this argument that you're putting forth. If you think that this argument has flaws, very evident flaws, naturally the judge will also see those flaws when you'll be putting forth that argument. So naturally have certain arguments which will be convincing. So if you have those arguments written in your arguments advance, that should be very more than enough for you to make it through, based on your memo at least.
Thank you.
No problem. Also, if anyone is interested, then I will be taking part in SLS Nagpur Moot Court competition, and I would really love if any one of you can just come along with me as a researcher, as a speaker along. Great. So just prepare to that.
Can I?
What? Who is it?
No, ma'am, like, can I try for that post, researcher?
Yeah, so you can you don't have to apply for the researcher expressly. All you have to do is that you have to submit your okay. So if you are taking part in this, just contact me in advance, and before contacting me in advance, just go through the moot proposition once. Okay, read it through and know that you'll be working with me, and I can get a little bit of finicky with details and with research aspects sometimes. But I assure you, it'll be like a really great learning experience if you are participating with me. And if we make it through to SLS, like we'll go through for the whole thing, and we'll argue together, and it'll be fun. It'll be great. And you'll see me succeed and you'll see me fail. So it'll be like a great learning experience for you, first-hand experience. Besides that, if you are interested in any moot and you don't find any of your friend participating in it, you can contact me anytime and I'll be up for it. So that'll be a great thing too, regardless of it. Anything else?
How should I
Ma'am, only if we had a medium to like communicate, and if there is any limitation to like,
Limitation to what, Akhil? Akhil, can you repeat that? Limitation to what exactly? Okay, my contact.
researcher thing, right?
Okay,
Can I be
so
in?
see, the thing is that why I wanted to contact me beforehand, before applying is that so the memo can be prepared together. Once the memo is prepared together, you will have a substantial amount of research beforehand to take part in the internal, and there'll be like a more substantial chance of you clearing the internal and succeeding as part of the team. If like let's say more than 3 people have applied, which is rarely the case. So I'm just trying to poach some of you juniors into coming over to the mooting side and trying to convert you into it. So if you do end up, just please go through the proposition once, then contact me and we can prepare the memo together, and I'll help you go through what exactly will happen in the internal and how you have to clear the internal and each and everything. We'll go through it together, and when we end up clearing the internal, it'll be a great opportunity for you to just learn once how the whole process unfolds and how it goes. So that is something that we can do later. But also, please go through the moot court notifications that are there on the Facebook page. Go through them, read the moot propositions, see if the law that the law that the proposition is covering is something that you think you are comfortable arguing over, comfortable researching with, and whether your whether your current engagements allow that much of depth of research, because mooting is a very, very much of a grinding, grilling, and hard-working job. If you cannot read substantially, do not go for the moot without having an interest in the law. If you cannot keep on rubbing your head and hitting your head against the wall regarding the same factual matrix, do not end up going for something that you do not like and that you are not passionate about. Okay, so just go through the notifications there. If you find anything interesting, or if you think there's a moot that is interesting and it is not notified, let your MCS people know, and they will, and then they will hopefully notify that. So there's that.
Naman, can you switch off your...
Naman, can you please turn off your mic? Oh yeah, sure, Naman, go ahead. Then we'll come to Nirupam. Yeah.
I just want to ask you a real-time question. If an average student is not able to participate in a MOOC, or he will not get a chance in internship or not get placed in third year, is it
okay.
fair?
So Naman, the thing is that your mooting actually reflects how committed you are, right? How well you have dealt with your research skills, and how well you have dealt with drafting skills, and how well you are in advocacy and oral advocacy, most importantly, because this gives an opportunity for the firms to adjudge you beforehand and to know if and to know how much they have to train you accordingly. So mooting is just a factor of that. If you have, like, let's say, research papers instead, which is also, by the way, a thing that I'm working on. If you have an interesting idea that you think we can co-author, please come ahead and contact me, and I would love to work on a research paper, especially criminal law. Love that aspect.
How do we contact you?
You
Yes,
get my
ma'am,
number
please.
from Fuzel. You get my number from Fuzel. That's it. So yeah, I'll leave my email though, so you can contact me over email. But if you want my contact number, then you have to go through Fuzel. No one else. I'll just leave the email here. Okay,
Also
so
mention the proposition that you are working on.
Oh, okay. So the SLS thing is actually on constitutional law, and I have not see, the thing is that when we actually read in our syllabus the case mats, they only cover like a very basic part of the whole law field. Like for example, whatever you're studying in family law is actually very basic. You're studying only the basic principles of family law, nothing more than that. When you take part in a moot court competition, you end up researching on a lot of intricacies of the law, and you go in a in-depth expedition to find out what exactly is meant by this term, what exactly is meant by that term. Like for example, if you would read your constitution in your third and fourth semester, you will not be taught about the differences between a curative amendment, an explanatory amendment, a clarificatory amendment, and what else? Yeah, these are the three amendments that are there. Or beneficial interpretations, harmonious interpretations, strict interpretations, literal interpretations. So like there are different rules that you use, right? So you will not be able to differentiate among them because you're not taught about them. But when you study for a moot court proposition and when you study for a moot court competition, you study the final details of it. So I studied constitutional law in third semester and I'm still studying in fourth semester, part 1 and part 2. So SLS is on constitutional law, and I felt it was a great opportunity to learn about the in-depth knowledge of constitutional law. Once again, go through the moot proposition once and then come to me, okay? If you like it, if you think you can endure it, then come to me, okay? Because Fazal will tell you, I am a very, very finicky person when it comes to researching and when it comes to working on a moot court proposition. And if you have any research paper thing on criminal law, then I would really love to be a part of that also. If you want me, if you want my help in co-authoring it and everything in it.
But
Because I
won't
just
it be a problem that we haven't yet studied constitutional law?
I have not studied taxation either, Aditya, and I went for K.R. Ramamani tax moot court. So it will not be a problem.
Then I'll definitely contact you.
Great, Aditya. First read the proposition. I am telling you right now. See, the thing is that you will have to teach yourself certain legal fields regardless of you being a law student in law faculty. So it's just better that you know how to teach yourself. You know the skill of self-teaching. And moreover, there are a lot of the times when in exams we have not attended several classes of a particular subject, so we end up teaching ourselves that subject. So it's just similar to that, nothing more. The thing that I am interested in is SLS Nagpur Parimal. Yeah, that was your question at least. So that is it. That's all I had to say.
Supposition.
It's on the Facebook page. It's on the Facebook page of Moot Court Society, Nirupam. You can just go over there and you can go through. There are also several notifications and there are several moot courts that I'm actually interested in taking part in, but I've not gone through the proposition yet. I've just pinned them on my dashboard for me to go through sometime Tuesday or Wednesday. So just be aware of that, and please go through it before contacting me to take part in. Because if it's something that you don't like or if it's something that you cannot endure, then it will be a huge problem for you. Not like it will not be a problem for me, but it'll be a huge problem for you. So just be sure of that.
It's the one from 9th to 11th April. Wala.
I don't know the dates actually. I'm not sure about the dates, so you might have to check that. But if you do want to work on a research paper on any subject from family to tort to criminal, I would love to be a part of that because I just really love writing and reading. So yeah, just let me know. Anything else?
No.
Perfect. Okay, all right. So see, the thing is that why I'm insisting on research paper thing is that you once you get a chance to work with me, you'll get to know how I work. And a team compatibility is very much an essential component of a moot court competition. If you don't have that, you don't have a win. The best chance that you have then is winning a best speaker award through your prelim performance. So yeah, so just be aware of that. But yeah, so you have my email and Fuzel will give you my number if you need it. And I believe you don't have any further questions, then we can wrap this up. If you have any further questions, you can contact me via email or you can ask Fuzel for your number, for the number and ask me help. But do not ask me what case to prefer for FIM because I will not tell you that. I'm telling you right away. I'm not going to help you in your argument formation for the moot court. That's completely up to you. That's your skill to be put in use, to be applied and then extricated from. So just be aware of that. That don't come to me for that help at least. But besides that, you can come to me for anything. Trust me, anything. You can even discuss how shitty Delhi weather is, and I will happily rant to you about that, and I will listen to your rant also. So yeah, I think that's
Thank
it. No problem, Nirupam. It was lovely having this discussion with you guys, and I hope that you got something useful from it. Moreover, I think you'll have more doubts when you finally do start researching, when you finally do start writing. So if you do have those doubts at that particular point of time, then Fuzel will be hosting, I believe, a couple of other Moot code workshops anyway. And if you still have them, you can always contact me regarding the disposal of those doubts. I hope that suffices now. So we'll just wrap this up. And that's it, I believe.
Thank you so much.
Thank you
No
so
problem.
much. Thank you, ma'am.
No problem.
Thank you, ma'am.
It was an
Thank you
honor.
so much, ma'am.
Oh, thank you, everyone. It was an honor hosting you guys. All right. And anyone can leave now. I will be staying here until 2, just in case if someone was embarrassed to ask the question, because they thought it was a silly question. So I'll be staying over here until 2 to 5. And so, yeah. So I'll be here. If you leave and if you just want to ask me a question in a personal space. Yeah. All right. Thank you, Shrija. All right. Bye now, everyone. Take care. Stay safe.